A new term began this week at the U.S. Supreme Court. The justices will revisit unfinished business regarding gun rights, free speech, executive branch regulation, and very likely abortion. The High Court will decide whether to hear a case that could uphold a lower court decision to limit the use of the abortion pill mifepristone. It will hear an appeal of its own guns right decision last year that strikes down a federal law disarming people who have committed domestic violence. Justices will hear 3 cases that could limit the regulation powers of executive branch agencies, and they will confront First Amendment issues regarding free speech on the internet and regarding abortion. Amy Howe, reporter for SCOTUS Blog, joins us now with insights on this court term. Amy, here we are, another term. Contrary to other Supreme Court terms that have been blockbusters for religious freedom and abortion, this Supreme Court term is being dubbed the cleanup term. Why is it being called that?
Well, frequently when you have these blockbuster terms, the next term comes along and it's a little bit slower. Certainly there are, as you just mentioned, a lot of really important issues. And then the justices are, as in some cases, for example, involving gun rights, having to explain or sort of flesh out what they meant in some of their earlier decisions. Like 2 terms ago, we had the landmark case involving gun rights out of New York, where the court in that case struck down New York's concealed carry scheme. But now they have to say sort of what the rule that they established in that case, which is that when you're talking about laws that restrict gun rights, you have to look at whether or not back at the founding of our country, when the Constitution was drafted, there was a historical tradition of having these kinds of restrictions. And so what exactly does that mean? Like how close an analogy do you have to have? And so that's the kind of thing that they're going to have to address this term.
And it really is important to give that guidance so that we're not taking all of the cases, back up to the Supreme Court. So that's an interesting thing to watch. There is one case that is very in the weeds legally because it deals with the powers of government agencies. Can you describe for the everyday man what the Loper-Bright case, also known as the Chevron deference case, what's it all about?
Yeah, so this is a very important case. It is, as you say, a little bit in the weeds. But back in 1984, in a case called Chevron versus Natural Resources Defense Council, the Supreme Court said that when Congress passes a law, if the law is ambiguous and a challenge to the law or a regulation that a federal agency issues pursuant to that law comes to the Supreme Court or goes to a federal court, the federal court should defer to the agency's interpretation of that law as long as it's reasonable. So even if the federal court looks at the law and says, gee, I would interpret that a different way, the agency's interpretation is going to prevail as long as it's reasonable. And the idea is that Congress can't, when it passes the law, address every possible permutation that comes along. And agencies have the expertise to administer these laws. The Environmental Protection Agency, the argument goes, has more expertise on environmental law than a federal court does. So this doctrine, called the Chevron doctrine, has been on conservatives' radar to overturn for quite a while, because their argument is that if you're talking about a law that Congress passed, the people who are supposed to interpret Congress's laws are courts, not federal agencies. And if we're deferring to what an agency says, then we're not doing our job properly. And, under this Chevron doctrine, there have been studies that show that the agency's interpretations are overwhelmingly likely to prevail.
That's an interesting way to assess it and kind of predict a little bit of the outcome. But in this case in particular, we're talking about fishermen, right? What's their story?
Yeah, so this is a story about, who has to pay. Yeah, there are fishing vessels, and they have to host observers to make sure that they are complying with fishing laws on the ship when they're out there fishing. And essentially it's a dispute about who has to pay for it, because, these people take up space on the ships and it costs money, and who has to pay for them. So it came to the court as, and that's how sometimes these disputes arise, as these sort of relatively mundane disputes that then come to the Supreme Court and present these really important issues, legal issues.
Well, now let's move on to the cleanup around abortion. Obviously, the Dobbs case was huge, but now we're looking at medical abortions, the mifepristone pill issue. What are the chances that the Supreme Court will hear the FDA mifepristone abortion pill case this term?
Oh, I think the chances are very high. And so this is a case in which the U.S. Court of Appeals for the Fifth Circuit upheld part of a lower court ruling so that it is significantly restricted compared to before, access to one of the drugs used in medication abortions. And medication abortions account for roughly half of all abortions in the United States. Groups had challenged the availability of this drug, the FDA's decision to certify it. And the Fifth Circuit said, that the FDA approved it too long ago to actually be able to, for them to be able to challenge the initial decision to approve the use of mifepristone. But it agreed with the lower court that the 2016 and 2021 actions by the FDA that increased access to the pill, for example, allowing doctors to prescribe it via telehealth appointments and making it available later in pregnancy, should be rolled back. So the Biden administration came to the Supreme Court asking the justices to review that decision. The other side is the groups that were challenging the regulations are likely to file their brief opposing Supreme Court review at the beginning of November. So we almost certainly will hear before the end of the year whether the justices will take up the case. If they do act on it by then and agree to weigh in, the case would likely be argued in March or April, with a decision to follow by summertime.
Wow. Well, that's a quick turnaround. I can't let you go without talking about the issue of judicial ethics. It's looming over the entire court. Under particular scrutiny is the previously undisclosed luxury travel and other gifts accepted by Justice Clarence Thomas. What can we expect there? Will there be any movement on establishing an ethics code on financial transparency?
Justice Kavanaugh, at a recent appearance before a group of judges, said that he was hopeful that the justices would issue their own ethics code for a variety of reasons. They, say that they try to adhere to, but are not bound by the same ethics code that apply to other federal judges. So they have said back in 2019, I think, at a House budget hearing, Justice Kagan said that they were working on one. So we will see whether they issue one soon, as Justice Kavanaugh said. I think this is something, I have absolutely no inside information. I think this is something that they would all have to agree on. And then there are serious questions if they don't agree on one. There are serious questions. Justice Alito, for one, has raised them about whether or not Congress has the authority to impose one on the Supreme Court. So it's a very interesting topic, and definitely one that I'm keeping an eye on.
Well, one to follow and one we will ask you more questions about later. Thank you so much, Amy.
Thanks for having me.